Hello there, wherever you are. It's evening in London, and I'm here this evening with Helen Sedwick for this month's ALLi Insights from the Alliance of Independent Authors. We bring you once a month an expert in publishing, self-publishing, author publishing, and it's my very great pleasure to introduce you this evening, those of you who don't know as yet, Helen Sedwick, attorney at large, author of the Self-Publisher's Legal Handbook, which is a really invaluable source of information. And she's going to talk to us tonight about all things legal that you need to know. So good evening, Helen.
Good evening, Orna. I'm glad to be here.
Thanks so much for coming by. It's a minefield, right? The legalities around books and publishing grew up in a time where, you know, there was a publisher and there was an author, and they weren't the same thing, generally speaking. So now we have also publishing, self-publishing, and people stepping into sort of a whole legal system that's really made with them in mind. Is that right?
That's correct. What many people, when they start self-publishing or even doing freelance work, is that they are surprised to find that they are starting a small business. And so there are some technicalities to starting a small business, and then there are more complicated things such as contracts and responsibilities towards the truth and to others. So it takes a little education. I've been an attorney for 30 years, but I've also been a closet writer during a lot of that time. And I wrote a novel which I self-published, COYOTE WINDS. I self-published it in 2012. It's right here. And when I was self-publishing it, it really dawned on me how much this was starting a new business and how much writers needed help in the nuts and bolts of starting a business and understanding their copyright and how to protect their copyright. So that's why I wrote Self-Publisher's Legal Handbook, which has been a very good seller, mostly because there's no other book out like that out in the market that really walks people through both the nuts and bolts of setting up their business, understanding what they own in a copyright, understanding some of the risks of using real people in the writing, and I even talk a bit about taxes. And what I'd like to talk about today is some information to help writers understand what it is they own when they create a piece of work and how to protect it, not from people stealing it, but from signing really bad contracts. Authors often worry, they think that their biggest problems are things like defamation or privacy. Actually, their biggest risk as a writer is signing a bad contract. There are a few hundred writers that get in trouble each year for defamation, but tens of thousands of writers sign really bad contracts, and it's not necessary. I think any writer who can handle character, pacing, voice can learn enough contract law to understand what they're signing, or understand that if they don't understand what they're signing, that they should get help. So I try to teach authors how to spot issues. And what I'm going to talk, go ahead if you have a question.
Well, yeah, I was going to, I suppose, just go back to you were talking about, it all hinges on copyright, yeah?
Yes.
So I was just going to maybe ask you to kick off there, but go ahead if you were thinking of starting somewhere else.
What writers should realize is when they create a piece of work and they put it down in writing on a piece of paper or on a computer, they own a piece of property, just like a bicycle or a house or a car. And just like you would want to control who drives your car or who lives in your house, you want to control this piece of property called a copyright. And you own that copyright automatically as soon as you put your original work into what's called tangible form, which is on a piece of paper or in a computer. You own it. It used to be you had to register the work at the U.S. Copyright Office in the United States, and you had to mark it with a C, circle, and a date. That's no longer required. Copyright attaches automatically. Now, it makes sense to put a C circle and the date, copyright notice on your work, and it makes sense to register the work because it gives you additional rights and it puts the world on notice, but it's not necessary. And a copyright lasts a long time. It lasts your lifetime plus 70 years. So your grandchildren and great-grandchildren could still be getting royalties from your work. And then in Europe, you have what are called moral rights, which give you additional rights to control your work, even beyond copyright. Now, let's see. I had some notes here, which I'm not finding, but let's talk about this.
Don't worry.
So let's talk about what's not protected by copyright before we go on to how to protect your copyright. The basic idea of your story cannot be protected by a copyright. So a deep space adventure or the classic romantic triangle, those kind of concepts aren't owned by any other writer. But if you write to that concept or that genre, you don't own it either. Titles are also not protected by copyright. This is painful for some authors to hear because coming up with a good title is very difficult. But the thought is it's too short to contain enough originality to be protected by copyright, and that we don't want to limit. We don't want to have someone be able to grab a certain set of words and own them exclusively. Now, that being said, if your title becomes really famous, like the Da Vinci Code, you're going to have what's called a trademark right in that name. People can't sell another book under the same name, but that's to protect consumers from getting confused. Also not protected by copyright are stereotypical characters like the gangster, stereotypical settings, as again, like deep space or undersea worlds. Sometimes short phrases can be safely used, but not lyrics. I always warn writers to stay away from using lyrics. You know, if you want to set a scene by having a few Rolling Stones lyrics that your character's thinking about, I recommend against that. It's not that lyrics are special in the eyes of the law. It's that music companies own those rights, and they're very aggressive about protecting them. So when you own a copyright, you write a book, nonfiction or fiction, you own the copyright in how you've expressed your ideas. Think of it as if you own a little strip mall. Strip malls here in the United States are these small little shopping centers on a corner, and that you get rent based upon the little shops and how much they sell. So you own the building. And think of all of those shops as being how you're going to sell your book. One shop might sell audio rights, audiobooks in Spanish. Another might do print books in Mandarin. Another might do e-books in English. So what you're going to do is you're going to grant what are called licenses to each one of these sellers. And that license is going to be limited. It's a permission to use, and it's going to be limited to what that seller can actually sell. And this is true whether it's traditional publishing or self-publishing. What you want to license your work, which is giving a permission to use someone to use their work, and you want to limit it to what they actually have the wherewithal to sell. And if they can't sell it, or if they don't get it out in time by a particular date, or if their sales drop below a certain amount, you get those rights back, which is called a reversion right. Now, this is a very simplistic concept, but it helps authors understand that they own the whole, and they're just giving away little parts, and to try to keep those parts as small as you can negotiate. Now, if you're going with the traditional publishing route, the rights you're going to give to each one of these shops is going to be exclusive. They'll probably be the only one who gets those rights, because in return they're investing in editorial, design, marketing. If you're doing the self-publishing route, then you almost never grant exclusive rights. You grant what are called non-exclusive rights. For instance, you can upload and sell print and ebooks through Amazon, Smashwords, Ingrams, and you can publish them yourself, get them printed yourself, and publish them over your website. So when you are self-publishing, you almost never give exclusive rights. There are a few exceptions like KDP Select, but those are the exceptions, not the rule. So where authors, I see the biggest mistakes are, there are some companies out there that act like they're traditional publishing companies, and they pretend to select their manuscripts. And then after they select your manuscript and flatter you, they ask for your credit card, because you are now going to pay for editorial. You're going to buy a package from them of services, editorial, design services. That's not a traditional publisher. That's a self-publishing service company that's really kind of trying to get you to loosen your wallet. Another place that authors make mistakes are contests that offer publishing contracts. Some of these are completely legitimate, but understand, if you enter a contest, and you win, you have agreed to sign their contract without negotiation, and probably without an advance and without a reversion right. So some of these contests that offer publishing contracts are really not that author favorable. It's a way for a small publishing company to go out fishing for manuscripts on the cheap. So do you have any questions? Do you think there are questions that your readers might have at this point about what a copyright is and some things about contracts?
Yeah, you mentioned, keeping it as small as possible, and I guess that applies to the term of the contract as well. Should a writer, or are there times when a writer might want a longer contract from a trade publisher specifically? Self-publishing contracts are in many ways more straightforward in that sense.
Well, with a self-publishing contract, you should always be able to terminate it right away, anytime you want. Because think of a company like Amazon is really working for you. I know that's hard to believe, but you're hiring them and you're paying them a certain amount of money from each sale to put your book on their website and handle distribution. They are a service provider, and you can end it at any time. And that's true whether it's BookBaby or Mill City Press or any other company, or even Ingram's. You can terminate it at any time. If you are signing on with a self-publishing company where you can't terminate easily and quickly, that's a bad sign. So what I should say is, how are you going to know what your contract says?
That was my next question.
You're going to have to read it. You're going to have to read it. Now, this intimidates a lot of writers. They think that contracts, as I say, look like 5,000 words run through a blender. They just look like a mess. So what I suggest is, don't start at the beginning of the contract. You'll be worn out before you get to the really important part. Start with a provision that usually is titled something like grant of rights, license, ownership. Read those, and you'll start seeing some patterns. And in fact, in the Legal Handbook, I take a contract at the back of the book and I break it down phrase by phrase on what things mean. And if anyone emails me, I'll be glad to send them that little chart. But you want to look for words, especially for non-publishing contracts, you want to look for a non-exclusive right to, and then it should describe, print and sell your book, format and sell your ebook. It should be fairly specific. And that's a good contract. A bad contract will read something like this: that author hereby grants publisher the exclusive, worldwide, perpetual right to produce your book in all formats, in all languages, in all countries, for the life of the copyright. Those contracts are out there. Once you take a look at a couple contracts, it'll be so glaring what the difference is. The next place you look in the contract is termination. How do you get out of the contract? Because you might get picked up by a traditional publisher. So you want to get rid of Amazon and Ingram's. You're going with a traditional publisher. So, and if you're going, if instead you are going with a traditional publisher, that's what you were talking about, term. How do you get out of it? If they are continuing to sell your books, then chances are everybody wants the relationship to continue. But if they've gone on to a new sweetheart book, and they're ignoring your book, and you're selling 3 a quarter, 10 a quarter, some level, you want to negotiate at the start a right to get out if once sales drop below a certain point. So you have to learn how to read some key contract provisions. Have you come up with any way to get authors to actually read contracts? I mean, do you have people who come to you and say, yeah, I don't want to read it, I don't want to deal with it? Because I certainly do. It's why are authors so reluctant to actually look at this thing that is actually the basis of their income? I think they've become intimidated by the law without realizing the law is a tool. Law is not a religion. It is not, it's not fixed in stone. Law is a tool, and it's a tool that business people use all the time. And how do I convince authors this is important? Hopefully they learn before they have a bad experience. But the only way I can think of is to talk to you and do a Google Hangouts and write a book to give writers the information they need so they don't feel so intimidated. And then if you go back to think about before you started writing your book, before you wrote the first word and you had all these ideas around bouncing around in your head, it's scary. You think, how am I ever going to get from the beginning to the end? But you do it word by word. You get there. You break it down into steps. Same with the self-publishing process. You break it down into steps so it's not so intimidating. With reviewing a contract, I'm saying, look at the grant of rights provision in the contract. Start with that step. Chances are, if that provision is fair, the rest of the contract is fair. I give a couple other suggestions that I think sometimes are easier for people to understand. For instance, if you're going to be signing on with a self-publishing company, see what it would cost to buy your own book, copies of your book. Some self-publishing companies, they charge you their printing costs, maybe with a small markup. That's appropriate. Other companies will charge you like $15 a copy for your book, which is 3 times probably what his printing cost is. Chances, I would say, a company that's charging their authors 3 times what the printing cost is for the book probably has an unfair contract across the board. So that's like a non-legal test that people can apply. Now, what are you going to have to pay? Because you're going to buy a lot of books to give them away and to sell them yourself. And if you can't make a profit if you have to buy your books at $14 or $15 and sell them at $16 or $17. It's not going to make any sense. One of the problems that we meet most often with writers who are unhappy with the contracts that they have signed is that they inadvertently have gone with one of these companies that you were describing earlier that really have no interest in selling books at all. They're really only interested in selling publishing packages to writers, and that's their business model. And really, once that book it's really only printed. It's not published in any real sense of the word. And they offer marketing and promotion packages that are extremely expensive and achieve very, very little. Is there anything specifically within a contract that you can kind of look out for? Because one of the problems with these companies as well is they keep changing their names. Some of them, we list them in our choosing a self-publishing service, ones to avoid and ones to look out for as being good. But
you know, it's a rapidly shifting landscape, and they change names and so on. Is there anything that you can say, you know, warning sign?
Well, of course, it's best never to sign on with one of those companies, but if you have, I've heard of a lot of people having success. Most of these companies, all they're interested in is selling you packages. They're not really interested in selling you books. They're selling you packages. And usually they have not adhered to their own contract. They are so sloppy that they haven't given you royalty reports. You'll see that your book has a sales ranking on Amazon, and they'll tell you you haven't sold any books. So sometimes what it takes is you write them a very aggressive letter saying, here's how you have breached the contract, and I want it terminated, and I want you to stop selling my book right now. And you know, that will work. In 99% of the cases, that's going to work because they've already gotten their money from you, your money from you, and they don't really care about selling your book. So if you send them a strong letter insisting that they terminate the contract, stop selling your book, and revert all the rights to you, that's probably going to work. If it doesn't work, let me email me through my website.
You heard her. She said it. Yes. Thank you very much. Helen is a fantastic resource for authors, and we have invited her, in fact, to become our legal advisor, and are delighted to say that she has accepted. And she's going to be working with us closely on our new upcoming book called How Authors Sell Rights. So that's one to look out for later on in the year. We'll be launching it at Frankfurt Book Fair, hopefully, all going well. But when you say work, what you essentially mean is it'll work in the sense that you can get your book back and they no longer own it, but there's nothing in that contract that actually protects a writer whereby they can say, hey, you owe me money, you didn't actually deliver what you promised.
You can always sue them for breach of contract. It's rarely going to be worth it. By the time you hire an attorney, litigation costs not only a lot of money, but it's so stressful and it just preoccupies your mind. It may be sometimes you have to cut your losses and just say, okay, I learned an expensive lesson, and then write about it on your blog, talk about it with your writers groups, and hopefully save others from making the same mistake. But if many people who make this mistake have taken a shortcut. They've looked at self-publishing, they've gotten intimidated by the process, or they did a Google search and they stopped on the first page, and so they got one of these companies to go the easy route. Well, there is no such easy route. Having gone through self-publishing and having seen other people go through self-publishing, I want to assure listeners and writers and readers, it's not that hard to be your own general contractor and hire the freelancers and put your book together yourself. You can do it. You can control the budget. You'll be much happier if if you have direct contact with the people who are actually working with you. Most freelancers love what they do. If you take the process step by step, it can get from the start, from the manuscript to the book on the market, without too much difficulty. It just takes a little time.
You're singing our song. I mean, that is absolutely what we recommend people to do. And I don't blame authors in some ways, because very often it's just about not knowing any different. And as you say, these companies have Google sewn up. I mean, I can't think of any other industry where there are people flagrantly not delivering who are still appearing at the top of Google search, and not just top 3. I mean, the first few pages, it's a kind of it's a sellout. So, I mean, we're on a mission here to try and change that. And it's very much at this point about educating authors to to learn that first of all, that there is a different way, and secondly, that it isn't that difficult because we support each other. There's a huge amount of help from other writers and from people like Helen who give their time very generously and their expertise to help you each step of that way. Back to copyright, because it is what they call a passive right. Could you talk to me a little bit about that? It has to be asserted as such.
Yes, there are no copyright police out there who are going to enforce it for you. You have to understand what you own, and there are some measures you can take to protect yourself, and then there's some things you just have to live with. It makes sense to register your work. In the UK, there are private agencies that register the work. In the United States, you register with the US Copyright Office. Even if you're not a U.S. citizen, you can register with the U.S. Copyright Office. It will create evidence of when your work was created and what your work is. It's very easy. You go to U.S. Copyright Office website. It costs $35, at least for U.S. citizen. I think that probably for the same for everybody. $35. It takes about 15 minutes online, and then you send in 2 copies of your book. It may be 8 months or a year before you get your nice little certificate back, but your registration is effective as of the date you fill out the form online. Some people then set up Google Alerts with the first 50 words of their novel or the last 50 words of their novel, and so that they'll get notice if somebody's posted their novel. Probably something in the middle or the end's better, because the beginning of your novel might appear on a number of sites as part of your sample. But so you want to keep track of where your book is and where it's been sold. But writers should realize that there are all these sites out there that say, download a free copy of Helen Sedwick's Self-Publisher's Legal Handbook. Free PDF. If you Google your title or your name, you're going to see between 5 and 20 of those. The common wisdom is they're not really selling your book. They're selling malware. They're trying, because they're doing it for free. So they're not doing this. No one does anything much for free. They're doing this because you would probably have to register with them. They're going to download malware, or maybe you have to give them a credit card. So as for writer, you can chase them down and send what are called DMCA takedown notices, but it's not worth your time. You just look the other way. We all get letters from a bank we never heard of saying we need to verify our account. It's just life on the internet. You could waste a lot of time chasing these guys down. In reality, the people who are going to read your book are willing to pay, especially for an ebook, they're willing to pay the $2.99 or the $4.99 or whatever price you set. Books are not that expensive. Your real readers will pay for it. In terms of blog posts, it's the same thing. Blog posts also get stolen. There you can email the people who take them, and you at least want attribution and a link back to your site. And in 95% of the cases, the other blogger will apologize and do that. And the other 5% of the cases are probably not worth chasing. Orna, I'm going to check my internet connection, and so I'm going to lean away for a second and just check my internet connection. Okay, I'm thinking that, there we go. Hopefully that'll make things a little bit better.
Okay,
I'm back.
Thanks, Helen. Welcome back to the piracy thing, because there is also a sort of a received wisdom that you're better off to be pirated. Paulo Coelho, I think, is the most famous proponent of this point of view. He was talking, I think it was Russia, I can't remember the territory, but his book started to be pirated in pretty grand scale, and the result was that his sales also went up really, really high. So he sees piracy as a sort of a marketing method. I wonder about your thoughts on that.
That would be great. I mean, that would be great. And it just falls into those categories. You can't probably do anything about it, so you might as well go for the ride, and hopefully it turns into something for the best. That's a great
good
result.
stuff.
I hope everybody has that result.
No, indeed. Okay, so I think we're pretty done on copyright there. What other legal issues are are key for writers to look out for?
Well, let's talk a little bit about using work owned by other people. I just hope that listeners realize that just because something's on the internet doesn't mean it's free to use, that work no longer has to be marked with a C copyright. Somebody could own that image, that essay, that poem. So you have to learn when you need permission to use an image or lyrics and when you don't. Again, if people go to my website, which is helensedwick.com, and if you go under resources, because I get this a fortune or a lawyer, and one is how to use memorable lyrics without paying a fortune or a lawyer. It'll explain about the fair use exception, public domain resources, and if you do need to get permission, some ideas on how to track down a copyright owner and how to ask for permission. Especially if you're going to do a blog and you want to use images, it's just part of your toolbox. Consider these resources. Your toolbox is like, okay, how do I use images without infringing on someone else's rights? Probably the next thing, we could talk about using real people in your writing. Okay, your eyes opened up on that one.
Yeah, this is one that comes up all the time. I want to write about, something that happened in my family or something that happened in my childhood or whatever. It's a novel, and I've changed the name, so I'm safe, right?
Okay. Here I'm going to talk more about U.S. law, but in Europe, if anything, it's a little bit tighter and harder for writers. I mean, the writers have to be more careful. But being a California attorney, I'm going to be more familiar with U.S. law. In general, I want to assure writers that you can write about your Aunt Ruth, you can write about your ex-husband, you can write about Donald Trump, you can use other people in your writing. I think if writers couldn't do that, 95% of books would disappear. But there are some common sense limitations. For instance, defamation is a statement of fact, a false statement of fact, that causes reputational harm. And in the United States, if it's a public figure, you really have to know it's false or have been very reckless that it's false. So it's a very hard case for somebody to win. What you have to state has to be false, and you have to kind of know it's false. It has to be a fact. If it's an opinion, if it's parody, if you're doing The Onion or you're making a joke about somebody, you can absolutely skewer them, pretty much. But because it's a farce and it can't be seen as really true facts, you're protected. At least legally. So the trick with defamation is, what I say, if you're writing the Getting Even book, is write it in the heat of passion, then put it aside till you cool down, and then revise it with a more objective eye. You'll probably make your story more universal and less of a Getting Even book, and it will probably be a better book. Before you shoot off a blog post or something that's could be quite damaging to someone's reputation, give it to somebody else to read, somebody with a cool head, and just take your time. Just basically be careful what you say, that you wouldn't say something that you wouldn't shout out in a room full of lawyers. It could be a good rule of thumb. That's very simplistic, but that's some ideas. Oh, another thing about defamation is if you are going to talk about something wrong that somebody did or that you want to bring attention to, show, don't tell. Describe the facts, what happened, how you felt about them. Let your reader come to their own conclusions about that other person. Don't take the shortcut of saying somebody was a crook or a nincompoop or an idiot. Let your readers apply that label, and as a writer, say what happened and say how you felt about it. And you can even say your opinion about it, but avoid labels. The next issue is privacy. If you're writing about family secrets, okay, to get in trouble, it really has to be a secret. If the fact that your Uncle Joe was a drunk is known by everybody in the neighborhood, that's not a secret. And you can probably talk about your Uncle Joe and what his drinking did to his family. If something occurred in public, that's not private. If somebody has a knockdown, drag-out fight on a public street and you want to write about it, unless you happen to be the only person there and it was 3 a.m., you can probably get away with that just fine. And the last potential risk is what's called the right of publicity. This is if you're writing, let's say, an unauthorized biography, or you're writing about Marilyn Monroe in your book. Generally, all of that is safe, is fine, as long as you're not piggybacking on the celebrity's fame or the celebrity's fame to the point where it's really an advertisement. You're really slapping Tom Cruise on the cover of your novel more for advertising purposes. If you are talking about a real person and it's related to your subject, or it's related to your plot, and it's of public interest. I'm sorry, let's talk about nonfiction. If it's related to your subject and the subject is of public interest, you have a lot of leeway. If it's a novel, again, you have a lot of leeway as long as you're really not trying to piggyback on that author's fame and just sell a book about Tom Cruise and a fiction about Tom Cruise because you think everyone will want a book about him. Very general statements. If you're going in that area, it's also just something to read up about and get more sophisticated about.
Fantastic. We have about 5 minutes, so just to say, if anybody has a last question for Helen before she heads off, you can submit it through the Q&A function, and please do. What I love about reading your work and talking to you is that you make it all seem simple and very manageable, and yet it's my experience that a lot of writers are quite scared about legal issues. Is there anything to be afraid of?
Less than they think there is. I think what I tell writers when they ask me and they're worried about writing a particular story, I say write it, revise it, work on it. Chances are, as you're writing, particularly a memoir, you're going to come to some truths that even you're surprised at. And you may, by the end of the process, be actually quite fair to everybody involved. That's what people usually find when they're writing a memoir, if they really stick with it and get it to be the point where it's something other people are going to care about, is because you've gone beyond your story to make it a story that's going to mean a lot to many people. And you can even ask people that may be affected by your story to read it. And again, you may learn things that make your story better. Now, I'm, of course, just talking about the legal issues. I really can't do much about whether things are going to be awkward at family gatherings. That's something that a writer has to decide themselves, whether they, want to be the black sheep of the family. Some writers may absolutely enjoy that, and others may find it too stressful.
I think it's just part of the job description, really.
I mean, I think as Norman Mailer said, if you're a friend of a writer, you're fair game. Something like that.
I think that's a good line for us to finish on. So again, people, we've been talking to Helen Sedwick, who is, tell people where they can find you, Helen.
My website is www.helensedwick.com. That's HelenSedwick.com. You can find my book on Amazon or any online site. I have a blog on my website where I try to do a lot of what I'm doing today, take a topic and give practical, useful advice. I do try to answer my emails. I don't always get to all of them. But on the emails and comments, I do try to stick to general descriptions. I can't actually practice law outside the state of California, so my answers to people may be general information and not very specific to their circumstance. I do my best.
You certainly do, and very good indeed your best is, and thank you for it. You do us all a great service. And we'll be hearing more from Helen, as I said, later on this year when we publish our How Authors Sell Rights. And thank you so much. Internet was a bit of a struggle for us both there at times. Thank you for hanging on in there and giving us such great advice.
Glad to. Thank you.
Take care.